Kia ora and welcome to the Construction Industry Council Privacy Act webinar. As an association of associations, the New Zealand Construction Industry Council recognises that changes to the privacy law can have significant effects on our organisation and on our members. Updates to the Privacy Act came into effect on 1st of December last year, and the privacy laws have been updated to meet the needs of the 21st century and recognise the changes in the way we conduct business and collect information since the Privacy Act was first introduced in 1993. The Construction Industry Council have partnered with TwoBlackLabs to provide our members with an insight into what is needed to comply with the changes to the Privacy Act. TwoBlackLabs are a privacy consultancy with skills in law, IT architecture and design, project management, risk analysis and risk management. Our presenters today are Caroline Carver, who's the founder of TwoBlackLabs. She has previously worked for Deloitte's KPMG and New Zealand Customs, advising on privacy and cyber security. She is an IAPP qualified fellow of information privacy, holding multiple international privacy certifications. Caroline's backed up by Mark Carver, who's a director and principal consultant at TwoBlackLabs, and he has almost 30 years experience in IT, specialising in privacy engineering and operations and privacy by design. Caroline, please take over.
Okay. Nice to meet everyone today. So what we're going to do today is talk about the New Zealand Privacy Act and how it affects New Zealand organisations. So why is the Privacy Act changing? So the world of privacy is changing around the world. Europe changed their Privacy Act about 3 years ago now. And that was the introduction of what some people know as the GDPR. For that means that the world has changed their settings as well. So a lot of organisations have had to comply with GDPR, and then put the boundaries for the rest of the world to up their game. In New Zealand, we were one of the first countries with a Privacy Act, so we were really cutting edge when we had it. That was sort of 1993. Things have changed since then. So what we did over the last few years is we've had a number of failed starts to change our Privacy Act. So it has been talked about, it needs to be updated, it's not fit for purpose, it doesn't cater for the technologies, etc. we have today. A number of failed starts. Finally, with a hiss and a roar, it went through Cabinet during COVID. So key things to note, Privacy Act and the changes came into effect on the 1st of December last year. So everything we're talking about today, you should already have in place or be thinking about how to put things into place. So go through some of the key areas that we need to talk about and what you need to be thinking about. And at the end, we're going to have time for questions, etc., for anyone to ask. Recording. So if you have a privacy or a security breach under the new Act, you are required to notify people in certain circumstances. So the key thing to say is this is not every breach. This is only breaches where there has been significant harm or potential for significant harm to individuals. So first thing you need to do if you have a breach is to work out and go, is this potential to have significant harm to individuals? Now, harm is measured on individuals. It is not measured on your company's reputation, how your company is going to be portrayed as part of this. It's all about your end customers, your end individuals who interact with your organisation. So the thing is to do that analysis. If one of these notifiable privacy breaches, then there are two people you need to notify. The first one is the Privacy Commissioner himself, and To do that, there is a web form on their website that you go and you fill in and say, we've had a privacy breach. The other parties are those people who've been impacted by the privacy breach. So those people whose records maybe have been compromised by a security incident, or whose file you left on the bus or the train, etc., they need to be told about it, and they need to be told what has happened and what they can do to protect themselves. Now, notification stuff needs to happen in a reasonable time frame. So it's as soon as practically possible. So that's measured in hours and days, not weeks and months. To encourage good reporting, there is also a fine of $10,000 for failure to notify both at all or in a timely fashion. Of those fines, the fines and the details of the fines are made public. You don't want your name to be on that list. In terms of any breach you report to the Privacy Commissioner, that information remains confidential. So it shouldn't be a barrier to not doing those notifications. So other things that are happening. There is introduction of compliance notices. So under the old Act, the Privacy Commissioner could sort of stop you with his wet bus ticket, write on his Twitter account or in the Herald or Don Post about you, but there wasn't much else he personally could do to you. Things would have to go up to the Human Rights Tribunal to be dealt with there. So in the new Act, the Privacy Commissioner can issue compliance notices. So this is a notice that comes to your organisation to say your privacy is not good enough. You need to do something about this. Of those, they can say to you, you must stop doing something, so you must stop offering this service, you must stop using CCTV in your yard, for example, or it might say you must do something, so you must improve your signage, or you must inform people about a certain event. Now, those compliance notices are not optional, you actually have to comply with them, it's law. If you get one, price is not a consideration to whether you want to or don't want to comply with one. And you have a very, very short period to contest that. In that period of contestment, they are made public. So forevermore, everyone will be able to see publicly the details of whatever you have done wrong in the Privacy Commissioner's eyes and details of that. The other thing is they have introduced some new criminal offences. So these are mainly about doing the right thing. So it is now an offence to mislead the Privacy Commissioner's office if they're doing an investigation into you. It is also an offence to destroy personal information just because someone asked for it. And we'll talk a bit more about that in a minute. You will guess the Privacy Commissioner has been given a lot more power to ensure that you are complying and that you are doing the right thing as an organisation. At the moment, or previously, under the Privacy Act, you could request a copy of your personal information. So any of your employees can come and say, I want a copy of everything you hold about me. Any of your customers can do the same thing. I want a copy, everything you've got about me. There used to be a process by where you had a certain time period to answer, and you could withhold information on very small amount of grounds. The usual one that you would want to withhold on was commercial sensitivity. Now, there used to then be a whole bunch of backwards and forwards about can I release it, can I not, and a bit of an argument between the parties. So to resolve this, from the 1st of December last year, the Privacy Commissioner can now make a binding determination about whether you are or aren't going to release it. So if it gets put to him as a complaint, he will decide himself and you will need to follow that. Also has clarified what you need to do with your agents. Now, first up, these are not the secret agents sort of thing. These are agents in terms of people working on your behalf. So these are organisations that you contract to for something. So they may be a subcontractor. So someone you get to come and do your electrical work for you. It may be Microsoft, where you have your email with them. So those are some examples of how you can deal with what those kinds of people are. So the process is clarified, and it always used to be the case, but it's been clarified, that you are responsible for the actions of your agents in terms of privacy. So if you get a third party who does work for you, and they go and release all your information relating to your staff or to your customers, you are still responsible because it's your information belonging to your organisation. You're ultimately responsible for it. Means that, for example, if there is a breach in one of those agents, so say Microsoft has a breach of the data they hold for you, you are still responsible for things like the breach notifications, for telling people about it, etc. For organisations to know who the agents are, and it is not unusual for people to not have a full list. And the importance of that will come out shortly. People are doing it with their agents, so they are updating their contracts with them. So a lot of people didn't have clauses in those contracts about breach reporting. So a lot of people are rolling out those new clauses to say, you must tell us about a breach. You must actually comply with the Privacy Act, etc. Pieces to the Privacy Act that has come in is about data leaving New Zealand. Now, before we all panic and think, oh my goodness, loads of my stuff, particularly in the IT space, is outside of New Zealand, there is a bit of a distinction here. So if it is information that is held on your behalf by an agent, then this new provision doesn't apply. So if it's held by Microsoft or you in Australia, this doesn't apply. But organisation who has the information is using it for their benefit, then it does apply. So some key things where quite often it applies that you wouldn't expect is free IT software. So those of you who are using the free version of SurveyMonkey, for example, in the terms and conditions of SurveyMonkey, it says that they can use the survey data for their own purposes. And you agreed to that as part of the terms. So that one, they wouldn't be an agent. They're using the information for their purpose. So this provision would kick in. Now, provision kicks in when you are sharing data for someone else's gain overseas, then you need to have additional safeguards to make sure that that information is safe. And that is safe in terms of aligned with what New Zealand deems as safe. So there are a couple of provisions that can be used. It can be going to what's deemed a safe country. That list is yet to be developed and is coming in the next couple of months from the Privacy Commissioner. But safe countries are likely to be places where their privacy laws are equal to New Zealand's. Now, one thing to note, it is highly possible that Australia won't make that safe country list. And that is because in Australia, the Privacy Act there only kicks in after a company is earning a certain amount of money a year. So there is a smaller industries that aren't covered by it. Other things that can allow for this overseas disclosure to happen is a contract with provisions in place. And the Privacy Commissioner has got a lot of guidance on his website about standard contract clauses that can be used and examples of them that you can put in your contracts for these sort of disclosures. It is quite a large task to work out your overseas disclosures. Now, some organisations don't think they share much information outside of their organisation. But what they usually find is their IT team have quite a lot of this sharing, particularly when they use that free tools. Other organisations might be sharing a lot. So if you work quite closely in partnership, maybe with a parent group in Australia or a similar organisation in Australia, you might find you are sharing quite a bit of information backwards and forwards. Again, though, a reminder, if they are your agent, so they're only using the information for the purposes you ask them to do, then this doesn't apply. Changes. It has been clarified that the Privacy Act applies to all organisations who are doing business in New Zealand. So it doesn't matter if you are home based in Australia, the US, etc. If you are doing business in New Zealand, it applies to you. This is predominantly put in actually for Google and Facebook, who claimed that because they were based in the US, that the privacy laws in New Zealand didn't apply to them. So this clause has been added just for them. It's been clarified about the requirements for a privacy officer. So under the old Act, it was always a requirement for every organisation to have a privacy officer. Now, a lot of organisations can't find their privacy officer. They got lost in action somewhere. So it is a really good time to re-find that person in your organisation and re-establish that role. Now, the person doesn't need any special training or qualifications. It would be useful, but not required under the Act. But what they do need to do is understand the Act and champion it and its compliance with your organisation. In terms of that, you are allowed to outsource that capability if you wish. But it has to exist in some form or another within your organisation. Now, it can be a shared role, so quite a lot of people might make their legal counsel their privacy officer or their head of customers, etc. It doesn't matter who, as long as they have the skills and the authority to be able to champion it within your organisation. Now, I have been some changes to the information sharing arrangements. So these are predominantly government-based, but how information is shared between government departments. For some of you, though, these will take effect and become more apparent in the next couple of months. So there is working going on between some of the government departments about allowing greater access to their information. And I think over the next sort of 6 or 8 months, you should see some items in that space that will be of interest to you. We haven't gone as far as Europe in their Privacy Act. So there were a lot of people who said, hey, you know, we want it to be identical to Europe's. But the compliance burden for New Zealand business and organisations is too great for us to have gone as far as Europe. So we've gone some way. And the reason we've gone some way is New Zealand has a very special role with Europe. And that is what's called an adequacy country. So that means New Zealand is able to have information transferred to you from Europe to here, and we are deemed to have the same level of protections as a European country for that information. So that is really important for our trade areas, that we keep that status. So we have come a long way closer to the European legislation to enable that. Changes to this. There have been changes about how you collect information from minors. Now, the first thing to say about this, there is no definition in New Zealand law of what a minor is. So that is something that your organisation will need to consider in how it actually applies for you and for your business. So if you are collecting information from children, then when you collect information, you need to take a consideration of their vulnerability. So if you make a system, for example, or something with lots of flashing lights that really appeals to kids, they're likely to put whatever information they need into it to get them some fancy reward or something that they want out of it. Thinking these individuals who are going to live in society for many years to come. So just think about what is it you need from them and how do you engage with them. So when you tell them about what you're doing with their information, is that written in a language that children can understand? Or is it written in special legalese that even a pretty grown adult would struggle to understand? about this is all of the changes or all the items that used to be in the Privacy Act haven't gone away. Now, sort of make a big sigh of relief and think, oh, great, well, that's good. That doesn't sound like much to do. Most New Zealand organisations haven't been compliant with the Privacy Act for the last 25 years. So it can be as much a problem. As I said earlier, the Commissioner can smack you with his wet bus ticket up till the 1st of December. Now the Commissioner can ask, you know, give you a compliance notice, give you fines, etc. It improves the importance of being able to deal with that issue. So, to the old Privacy Act and what's in it today. So, it covers a number of areas for it. So, the first one is collection. And this is where a lot of organisations struggle. You are only meant to collect the information you need today for the purpose you have today. So we often see people collecting things like, what is your gender? As an example. Now, if you need to know someone's gender because you're using it for statistical purposes or you are working out whether something is going to impact on someone's health and safety, that is fine. But if it's got nothing to do with it, then we shouldn't be collecting it. So as a general rule of thumb, if you can't explain to a normal layperson why you need a field on an application form, for example, you don't need it. Get rid of it. So that's that collection. The next thing is, when we collect information from people, we need to tell people why we're doing it. So that is the form of a privacy notice. So in terms of that, that means that we need to make available to people details of what we're up to. Now, quite often that might be in the footer of your application form or it might be on your website. And it needs to be in one of those two places or even better, both of them. So those need to be present and correct. We then need to use it in a way that is sensible. So the first thing is we can only use it in a way that matches what we told people we were going to do with it in that privacy notice. So if the privacy notice said that we are going to sign you up for an apprenticeship and deliver an apprenticeship program, then that's fine, do that. If it didn't say, well, we will sign you up for marketing and send you marketing every month and put you on our newsletter and do all sorts of weird and other things, then we should not be doing that. If we want to go ahead and do that, we need to regain their consent to do that and advise of that change. So once we've done that and we've used it and we've got our benefits, quite often people then leave or we no longer need that information. Now, the Privacy Act requires us to delete things when we no longer need them. So many of you, I'm sure, will have a database of members. I bet you over half of you have a database of every member you have ever had. That is not appropriate under the Privacy Act. So under the Privacy Act, if they're no longer a member and they're not likely to be coming back to you, so maybe a year after their membership lapsed, they should be deleted from that list, unless you've got a justifiable reason they need to stay. Bearing in mind, if they come back in 10 years' time, the likelihood all their details are incorrect anyway. So you should be updating them and collecting new ones. Retention, as I was saying earlier, is one of the biggest problems for New Zealand organisations and one of the things we usually find in most places. And it doesn't just affect customers. I suspect a large number of you will find, if we do a bit of digging, that we've got every HR file for every employee you've ever had and everyone CV who's ever applied for a job at your organisation. They're usually always there. So part of this is about having a really, really good housekeeping time. In terms of that is then once housekeeping, then you can be sure that if you have a breach, you're not having one of those embarrassing conversations with someone who's an ex-member from 20 years ago. Because it's not a good relationship to have. Sorry, we had a breach. Why have you still got my information? Oh, we never got rid of it. all of this? So the first thing is, let's not panic. The Privacy Act has been around for 25 years, we've already said. The Commissioner is not coming to admire your compliance today. He's got his own job to do. So it is about having a structured work program and assessing your risk and working from there. What people are doing, they're looking at their internal policies. So putting a privacy policy internally for your staff. How do you manage personal information? What do you want to do? They are updating those contracts with those vendors who are acting as an agent, putting those breach notification pieces. And they are also reviewing and updating their privacy notice. Or if they haven't got one, finding one. What people are doing, looking at their process stuff. So what is your process for a privacy breach? What are you going to do? What forms are you going to do? Whose job is it? Looking at what you're doing with those Privacy Act requests that people can make. So that copy of all my information, and you've got a process for dealing with that correctly. Depending on the risk profile, is looking at how they review privacy in an ongoing basis in terms of project delivery. So that's quite often called a privacy impact assessment. Looking at how that's built into your business so that your privacy maturity and your compliance doesn't slide off after you clean it up. The biggest jobs is looking at these overseas disclosures. So that's about working out who it is and getting all the requirements met for that. All of this is about raising awareness for your staff. So a lot of people's staff are not always that clued up with what's required out of the privacy. So actually doing some training with them, some e-learning about what are the expectations, and raising awareness about the fact that this is now a serious issue and, you know, has quite big ramifications onto organisations if it's not done correctly. Going forward, so it's great. We'll tidy everything up. It will look wonderful for day one, but it needs to remain like that in your organisation. So thinking about how do you embed privacy into your organisation to ensure that everything you change going forward has this eye to making sure that it remains compliant. So that's where I spoke earlier about those privacy impact assessments to make sure that every business initiative or change has got that privacy lens run over it to make sure that the compliance is not slipping anywhere. Key one is preparing for the action. You know it's taken effect on the 1st of December. You've most probably, after this session, have now realised that you've got gaps. That is absolutely okay. Most New Zealand organisations have gaps still. But it is about prioritising what you're going to do. So getting a roadmap, working out what you need to do and in what order. The Privacy Commissioner is not going to fine people or issue compliance notices for people who are trying. So if you have got the right work program that you need to do to get compliant, that is okay, as long as you are trying and making efforts. The Privacy Commissioner has come out and said, if you are not trying, those are the people he is going to be making examples of. So he's completely aware that some people, this is going to be quite a lot of work if you weren't compliant with the previous. It is about taking those steps, keeping up and just improving things slowly. So we work with organisations big and small to help them get their privacy stuff in place. Couple of things we can do. We have a Privacy Act Readiness Assessment. It's free of charge. You can find it on our website and request it. And that will give you a tick list of things you need to have done for the new Act, so you can find out where your gaps are. If you have a slightly more complicated organisation, we can come and help you work through that and give you a more detailed and prioritised report. Other things that are on our website for people, there is more detailed videos of different areas of the Privacy Act to help people understand those, etc. we do have handy infographics of how the Privacy Act applies. So if we need it, those are available. Just email us, we can give you those. And those are really useful checklists for people to go, what do I need to do for this? All of the Privacy Act is about trust and confidence in your organisation and doing the right thing by customers, by employees with their information. So it feels like something you wouldn't want to tell your grandmother about, or it feels nasty and icky, and most probably under the Privacy Act, you shouldn't be doing it. But if you take a benchmark, you usually won't go far wrong with what the requirements are for the Act. We've got to cover today, but we're going to open the floor up for questions for people.
Just a reminder to everybody on the call that if you've got a question, please put it through on the chat. But just to kick it off, Caroline, question from our own organisation, Construction Industry Council. We tend to collect data on people who come to our events or contact us, and we'll add that to a CRM, and that's kind of common practice, and maybe use that to look for new members in the future. Is a practice such as that, is that actually acceptable under the or appropriate under the new Privacy Act?
Absolutely, that is appropriate under the Act and more than okay to do. The key thing about that is that you need to have given notice to those individuals that this is what's going to happen. So when you collected their information up, you need to have told them about that. It's also not appropriate to keep them for longevity's sake. But say, for example, they are receiving a marketing email from you every month and they haven't unsubscribed, then keep them on your database. That is absolutely fine. But if they unsubscribed and they haven't had an email from you for 12 months plus, then most probably you shouldn't still have them in your database.
That's great. Thank you, Caroline. It doesn't look like we've got any more questions on the...
We have one more from the Facilities Management Group. So, how responsible are organisations for sharing individuals' personal information from their social media posts? So, I'm assuming this is a question about if people want to put stuff on the social media, etc. So, in terms of that, if you put details about individuals on your organisation's social media posts, then you need to make sure that individual is aware that is going to happen. If they're then going to go and on-share that, etc., that is fine. But you need to make sure the person who's involved, take pictures of a photo, actually agreed to it up front to begin with for it. So another question about retention. So some of you keep lists for members who've been expelled so that they don't come back. That's absolutely fine. You've got a legitimate need. You can't issue them a license, etc., so they don't come back. So you have a legitimate need to keep some information about them. You most likely want to keep why they were expelled and a bit of information about them as a person. However, once the person is deceased, they're not coming back. So you can get rid of the information at that point. So we don't need it indefinitely, but we need to keep it for the lifetime of that group. Readiness checklist. So if you go to our website, www.twobblacklabs.co.nz, and you go contact us, there is a box in the tick box there that says, can you send me one? And Mark will happily send out lots of them this afternoon for people. Question about social media. We've been asked, is it just pictures we need consent for or wider? So if you share any information on social media about people, they need to have agreed to that in some way or another. So if it's in your privacy notice that we talked about, that any details about our customers could be used on our social media account, That is fine. You're all good. That's all you need to do. The key thing is that people understand that that's going to happen and can make an informed choice about whether they do or don't want to participate at that point. In terms of if you are running an event, what most people do is they put in the event sign up, a link to the privacy notice that says, as part of signing up, we're going to add you to our marketing list, we're going to put you on our newsletter, and by the way, we're going to be taking photos at the event and we'll be publishing them on our website. That way, if they want to come in a disguise, that's cool, that's their choice. Members, so that we can build our database, such as whom are members and whom are not. On that, it depends on what you're doing with it. So it is absolutely fine to keep demographic information. So you most likely don't need to know that Fred used to be a member, but it might be useful to keep information like they were a builder, they were 40 and they lived in Oamaru. That is absolutely fine to keep. We just don't need to keep it attached to the member's name and their physical email address and their home address. So if you want to keep statistical stuff, go for it and keep that as long as you want. Okay, so if you have a member unsubscribe to our newsletter, but they need to be in our database to access member-only resources on our website, how is best practice to handle that? So if you're a member, then they can remain on your database, not a problem. It means though, if they unsubscribe from your e-newsletter, you cannot keep marketing to them. That convenes both the Privacy Act, but also in New Zealand, we have an anti-spam act as well. So if we are sending e-newsletters in particular, we need to be very careful that every person who's receiving it actually said they wanted to get it. So that can be done in two ways. One, you can sign everyone up as part of a privacy notice or statement when they join something or when they agree to come to an event, or they can sign up some other way. But the key thing is when they say to you, I don't want it anymore, you need to take them off that list. But you don't need to completely rip them out of your database if you've got another reason for them to be there, like member-only content. So you just need a flag that says, don't send this person to, don't send this person the latest newsletter. Oh, other questions from people?
Looks like that's all the questions. Look, thank you again, Caroline. That's been really educational, and I'm sure very helpful to everybody on the call. Just remember, everybody there, that if you need any more help or further information, TwoBlackLabs, their website is literally twoblacklabs.co.nz, really easily found. I've looked it up a couple of times now. And they can help you with all your privacy needs. For our New Zealand Construction Industry Council members on the call, we look forward to catching up with you in a few weeks' time at our next council meeting on the 30th of March at Engineering New Zealand offices in Wellington. Thanks, everybody. Bye.